Welcome back from the wonderful short lunch. Hopefully we had all discussions and some of the issues which were raised in the morning session will come back maybe in a different way, different context. And our focus in this part of the session will be on the appointment and promotion. And let's see again how it was formulated. Not here. Yeah, an evaluation of judges. So 3 points, but as in the morning we will probably see that each of these issues has links with other topics. We heard some cases in the morning already with regard to, let's say, cases in the European Court of Human Rights and so on. So I'm very honored and happy to have here an exciting, interesting group of panelists. And I will always say a few words in the beginning about everybody. And so starting with my good friend, Frederick Zoll. He has the exceptional situation of being a professor, full professor, both in Poland, Jagiellonian University, and in Germany. So he knows both, let's say, views, both country cultures very well. And he has also been one of the major forces, major persons, contributors to the Eli Mons Corpus standards, and has broad experience of comparative law in many ways. And I must say, in this specific context, he is a person who was very actively, I think I can tell that, engaged for the independence of judges in Poland, in the circumstances which we know and which he will tell us more in detail. And as well, he's also very much engaged in relations with Ukraine, being a Dr. Honoris Causa from a university in Ukraine. So the subjects which we cover in maybe one or the other perspective in this panel, who would be better qualified than him, So please, Frederick, you can start.
Thank you, Alex. Yeah. Thank you, Alexander, for this incredibly kind presentation, which I do not deserve. But I would like to speak in this short time about the question of the defective appointment and its consequences for the judicial system. I will take, of course, the Polish example because it is quite unique for certain reasons. Of course, as we discussed, it could be also somehow generalized, but it has some special features which are also interesting and also they cause questions about the balance of gains and losses, how it should be, how we should work out, how to restore the rule of law without breaching the rule of law, which is also quite interesting challenge which we are facing. But I'm starting. My speech will be a little bit, of course, it must be. It touches political questions, not only legal questions. I have to disclose I'm a member of the Polish Codification Commission, which is situated in the Ministry of Justice, but of course I'm talking only in my name here and not to mix it up. Quite recently, the President of Poland, newly elected President of Poland, Mr. Nawrocki, refused to appoint 46 judges which have been suggested by the Judiciary Council. His explanation was that the judges, it is about promotion. They were judges already, so it's about promotion. So they were judges. We are in this system of career judiciary, and as we were discussing in our Mons Corpus principles, standards, we're trying to somehow to adjust the original text of Mons Corpus standards on independence of judiciary to the more continental framework of career judiciary, which has quite special issue. We have discussed also this internal independence. Internal independence is much larger, more demanding problem in the system of the career judiciary than in the system probably of the common law. But what has happened? So he rejected and he said, because these judges, these candidates for promotion, They signed different lists, for example, to the Court of Human Rights. They were protesting against certain political practices in the time of previous government, which tried to reform or destroy the Polish judiciary system. They were somehow politically active, and they made also judgments following sometimes following judgments of the Court of Justice, which were not recognized by Polish constitutional tribunal. It's a complex of Polish difficulties. Of course, in this short time, I cannot go into details. The problem with these judges is, and it makes it extremely challenging, but this strange voices, but okay. Somebody is talking. But these judges were suggested or proposed. Yeah, I know. These judges were proposed by the Judiciary Council, which is actually not recognized by the government and is recognized by the President of the state. What is the reason for it? We had this reform of government of so-called party law and justice until Szymon was talking about this. With this party lost elections 2023. They tried to reform Polish judiciary, and they created new judiciary council clearly with the clear or almost clear, there's slight field for discussion, but with clear violation of the constitution. What was the consequence? The judges, who have been appointed after this new creation of this new judiciary council, which has not represented judges practically anymore. The judges were elected by parliament. It was against Polish constitution. And this judiciary council of the new setting was excluded from the network of judiciary councils. So it was not recognized as a body really providing a guarantee, being a watchdog for the judicial independence. So the judges which are proposed by this judiciary council and then appointed by the president, by the majority of Polish judges, they are regarded as wrongly appointed and partially as no judges. And it creates incredible problem in the whole system of judiciary. We do not have actually the problem of external independence. This story with Nawrocki, with the president of Nawrocki and his denial to appoint these judges, it is a new phenomenon which really goes into the independence of judiciary as such. But this internal debate, actually at this moment we have a government who didn't want to influence the judgments, so somehow it was not an issue. But we have this two group of judges, and of course we may create more groups of judges, and Szymon was referring to the draft law. How does it work? But the problem is of incredible relevance now, because we are in the situation, the president which we have will be for next 4 years, and he is vetoing all laws which are suggested by the government or by the majority in parliament, trying to somehow to change the situation. But we have a model where actually due process does not function. Because if you started now a trial in Poland, you may have a situation that a new judge, so-called new judge, this judge appointed after the year 2018, will be at the panel. And if he decides the case, the second instance, if the second instance is composed of old judges, we call them paleo judges sometimes, this paleo judges panel, they will cancel this judgment and say that not legitimized person has participated in the procedure. But of course, there is incredible number already of judgments rendered already by new judges, which are not questioned. First instance cases or or just it was a happy situation for this judgment that only new judges were on the path, or it was an old judge who didn't question it. So it is completely unpredictable system at this moment, of course, which doesn't have, yeah, it is sometimes, yeah, there's not a due process guarantee actually. Now we have there is a number of judgments, of chambers of the Supreme Court, of the European courts. We have already a presentation about it, just the recent two judgments of the Supreme Court. The Supreme Court, the Chamber for Labor Law, composed on all judges, decided in the panel of 7 judges, which means it's a principle of law, so-called principle of law, binding for other chambers of the Supreme Court, said that the judgments which are rendered with participation of the Supreme Court judges, which are new judges, are just void, without legal effect. Then we have now recently joint decision of 2 chambers, joint chambers with majority of new judges, or probably only new judges participated, because generally the old judges refused to participate in a panel with new judges. They said, we don't apply the European law so far it concerns the composition of Polish judiciary. It has impact on functioning of Polish judiciary. Of course, to prevent these judgments of the Court of Justice of the European Union, we had also 2 judgments of completely politically controlled constitutional court, telling first that the Treaty on Functioning of the European Union is against the Polish constitution, and secondly that the European Convention on Human Rights provision on due process is also against Polish constitution, as interpreted in this way that it was against the intention of these parties. The problem is how to find a way out. And here is also another part of the story. Namely, in the time of the rule of Kaczynski government, Kaczynski was not the prime minister, but he was a person who was really the ruler of Poland at this time, of Kaczynski 2015 until 2023, of course, they have appointed already incredible number of judges, but it was opposed, but also very powerful associations of judiciary. We have 2 powerful associations. There is Temis and Justitia. Yeah, I know. And these 2 powerful associations, they played incredible role. This is probably the unique Polish features. But it was exactly judges going on the streets. It was a march of 1,000 ropes on the streets of Warsaw. Mass protest also of judiciary against the policy. So it was extremely important, and of course it was the problem therefore we had this disciplinary chamber used, weaponized for again by politicians trying to somehow to stop the judges which were opposing and protesting against the government. But today these judiciary associations, they play more complicated role, because they're trying to prevent any kind of compromise, acknowledging these new judges. And now we have these new judges as a problem, because of course we are already for more than, I don't know, from 2018, so 7 years where these new judges are in office. And they, of course, they make judgments in the name of Poland. These judgments are partially false, sometimes not, sometimes yes. And it's not possible just to dismiss all of these guys. The system will collapse. So we have to do something about it. But the problem is we do not have political possibility of making a compromise, because these 2 camps, and also this camp now of the democratic government is somehow also under impact. They are a little bit afraid about these judges associations, and they don't try to make a kind of compromise which could be probably settled and worked out, because they also fear a kind of systematic opposition by this judiciary association. So we have here quite incredible another development of the specific role of judiciary associations on the whole system. But of course, we have to say there are many in this new judges. There are also very different categories of people which are there. There are a lot of them. They are with completely new judges. They needed completely new, which means the entry judges after the School of Judiciary, highly educated, without possibility to refuse the appointment because it is they will have to pay back the the scholarships. So they are not the problem. This is this green group. And other groups are problematic, but probably the only solution is, and I was trying to suggest it in some discussion, to live in peace with general courts, probably to dissolve the Supreme Court, because it's not possible to maintain the situation and to appoint the Supreme Court newly. But of course, for this reason, we have to change completely the Council of Judiciary. But it does not politically. It's very difficult to manage because the both political forces fight each other in a way which we cannot find really a compromise. And this is a paradox. Poland is a well-working state, economically, procedural. Basically, it's a well-working state. But this collapse of judiciary is this kind of Damocles sword threatening the future of the country in a very serious way, in very unstable political situation. So we have a kind of example how it could work and what kind of political crisis could really undermine the very, very successful story of the development of a state. Thank you so much.
Thank you very much, Friedrich, for this really amazing and insight into this issue. We know that probably Poland is the most, I would say, most visible, not only visible, most extreme case, how far disputes about judicial independence can go. And this basically is a, let's say, fight between, within the political sphere, and a fight by the political side with the judiciary, which was, let's say, created under earlier circumstances. And we see also, for me, it was interesting to hear the new developments, which you just reported. We had so far mostly heard about the issue that after the elections, basically there's a turnaround with a view to following the rules, the rulings of the European Court of Justice. But it's not so easy to be done if one wants to do that, because when you have the president and the but you want to add?
Yeah, I wanted to add one thing, because I forgot it. The story of President Nawrocki was not complete at the beginning, because actually he rejected to appoint the judges who were proposed by this non-constitutional Council of Judiciary. So actually he done what the government would expect from here to do, but the justification of this rejection was completely against the independence of judges, and this is the paradox which we experience.
Yeah, thank you again. So we have a blockage in some way. The political system is blockaded, and also we have, in addition, the rulings of the European Court of Justice, Court of Justice of the European Union, which I don't know, said that these courts are no courts, these judges are no judges, basically, and Poland has violated its obligations, but there is no enforcement of that. So from the Polish perspective, probably from the governance perspective, the European Court of Justice has transcended its own powers. So we...
Not today.
At the time, not the government today, but at the time different. So it's also basically a dispute between the European Union organs and the Polish government, and the judges themselves are split. And how to handle that for the future, for the past, that's the issue. I think it's instructive from many, many perspectives, but we have to leave it here at the moment. And I am happy to continue now with Professor Dr. Caroline Expert-Fouquier. She's a professor at the University of Limoges. And what is interesting also from our perspective, she's the general secretary of an association which deals with research on the administration of justice. So it's basically not only the academic sphere, but also, let's say, the mixture between or link between academics and some kind of practice, which we hear. And Dr. Professor Fouquier is also interesting. He's a public law specialist. Many of us are civil law, maybe commercial law specialists, and it's one of the advantages of this circle, of course, to have these different views, because organization, of course, is of course not only private law, it's not only criminal law, it's not only administrative law. So one has to bring in the experience from, let's say, from different perspectives. So please, you have the floor.
Thank you. I would like to give a few concrete examples of the progress that has been made in evolving the judiciary, because that was a topic the organizers gave to me, but also point out that there are still many challenges and that we have often remained halfway there, and that it is risky. Indeed, significant progress has been made in terms of external independence, thanks to the bigger powers conferred on judicial self-governance body in the last decades. And I want to explain that judicial self-governance bodies doesn't mean that there is a monopoly of the judges. Nor in the composition of the bodies, nor in any aspect. This is just the idea that this is a place where the specific cases of the judges can be addressed, and they are involved. Okay, and in Europe, these bodies were granted powers to select, promote, and evaluate judges, among other powers relating to the management of judges and courts. And sometimes these powers are exercised by judicial councils, sometimes by judicial appointment commissions, or by promotion committees. For example, in the Netherlands, candidate judges are selected by the National Selection Committee for Judges, composed of 6 judges and 6 non-judge members. And this national committee was created in 2002, and it's not the same body than the Judicial Council. The Judicial Council, created also in 2002, deals only with the administration of courts. Okay, so there are 2 different bodies. Similarly, in England and Wales, opinions on recruitment and promotion are not the responsibility of the Lord Chancellor or the Lord Chief Justice, but on the Judicial Appointment Commission created by the Constitutional Reform Act in 2005. Of course, as the LI Mons Corpus standards state, these judicial self-governance bodies must themselves be independent, which raises the question of their appointment and compositions. And here we have many challenges. We have an example of blockage. You were mentioned blockage. Another example of blockage about the recent difficulties in Spain in appointment of the judicial members in the Judicial Council. For several years now, there is a failure of the Congress and the Senate to elect these new judicial members in the Council. And I have to say that initially the peer election, so the election by the judges, was introduced in 1980, but was replaced by parliamentary election in 1985. So a political process. And since then, all members of the Judicial Council have been elected through political process along partisan lines. This is a statement by the Venice Commission, okay? It's not only me. And there were recently calls for establishing a system of election of the judicial members by their peers, but of course lawmakers are unable to agree on such a reform. And the result is that at the moment, 36% of Spanish judges think that the Judicial Council disrespects their independence. But of course, the composition of these self-governing bodies is also sometimes insufficiently balanced. Judges are in minority, so it doesn't mean that they should be in majority, but at least in a pair. And for example, in France, my country, the composition of the Judicial Council described in the Constitution concerning the section with jurisdiction over judges' promotion falls short of at least one member, because there are 15, 7 are judges, and 8 are lay members. But there is also another challenge. This is the competencies of these self-governing bodies. Sometimes the competence may be still insufficient. Of course, and I go back to the question of what is a self-governance body, we should not assume that these bodies have a monopoly for many reasons. There are many reasons, explanations for that. The fact that when there is a dysfunctioning of the justice, the citizens held accountable the Minister of Justice, so of course he can have a say, he can participate in a sense. We have also the question of the chance of democratic legitimation, and I know that is very important in Germany. So, of course, the politicians can be part. And we have also the fact that in many countries, the executive has the legal power to appoint. And what we have in the majority of countries, we have a partnership. We have a partnership between the executive and the judiciary in the management of judges' careers. This is what Professor Shimon Chitwi described as the executive judicial sharing model with 4 sub-models. However, it needs to be pointed out sometimes partnerships can be problematic. And here again, I would like to give the example of France. The section of the Judicial Council responsible for judges' promotion has the power to propose appointments for the main judicial positions, so the members of the Court of Cassation, the presidents of the Court of Appeal, and the president of the lower court. It's about 400 positions. But for all the other judges, this is the Ministry of Justice who propose the appointments. Okay, so the Judicial Council has only it's not only, it's already good, of course, but he has a veto power. But he cannot modify, he can suggest, but in any way he can propose anything. And as stated by the Venice Commission, it creates a risk, not purely theoretical, but political considerations are taken into account when proposing candidates for a judicial post. And I would like also, there are so many examples, but just I would like to take 2 other examples. In Ireland, the Judicial Appointment Advisory Board, created in 1995, only prepares a short list of that rests in the hand of political actors. And in England and Wales, this is the same. The Judicial Appointment Commission makes some recommendation, and the Lord Chancellor can ask if he doesn't agree for over recommendation. So what we can think is that this body must be given co-management powers, and not only advisory boards. That was, I was saying that sometimes we have remained in halfway, and it's risky. And what I wanted to say that in a liberal democracies, judges are often, they are independent because politicians have so far respected the separation of powers and the independence of the judiciary. But will this always be the case? That was what you were mentioning with illiberal parties, with illiberal politicians. And regarding what has been said, the legal framework is not sufficient in many countries. But I would like now to address also the question of when the judiciary is more involved, can we say that it works well. And here again, I will give a nuanced answer, because this involvement of the judiciary poses new challenges in terms of internal independence that was mentioned several times today. On the one hand, judicial councils can be captured not only from the outside, but also from within the judiciary. And particularly, this is something that we see very, very often, judicial councils can also be captured by one of the judicial associations within the judiciary. And in Spain, again, some judicial associations have developed close links with the political sphere, and it's normal, it's logical, because the politicians chose who can be member of the judicial council. They have progressively developed close relationship. And I would like also to mention the case of France and Italy, where the judicial associations are not linked to a certain political party. But these associations have the monopoly to say who sits in the judicial council and in other self-governing bodies, like, for example, what we call in France the Advancement Commission. So, so here the problem is that judicial association endorsed all judicial candidates to these governing bodies. And maybe an alternative could be an endorsement by individual judges. But then the question is how many endorsements by how many judges, etc. But maybe this is a way to deal with this topic. And also there are so many challenges, but I have to limit myself. But when judicial governance bodies are free of any political interference, what we can see is that sometimes they are overly centralized, they are not enough representative, or they can threaten individual judges' independence. And just an example of a very highly centralized manner of dealing with the question of selection, evaluation. This is the case in Italy. Since 2006, there are local judicial councils established at the Court of Appeal level. Judges' evaluation is a task of this local judicial council based on observation by the court president. These local judicial councils can interview the judges to complement the court president evaluation, but it looks like with these local judicial councils have been marginalized. The duties have been marginalized by the judicial council at the national level. So by that's really a pity. And I was very interested this morning when listening to the dean of the law school of the University of Nicosia, mentioning the fact that here Supreme Court judges have a monopoly on the disciplinary function for all the judges. And he was calling for a wider composition of the inspection body, for example, with a member of the Bar Association. So these are examples of the fact that also these self-governing bodies should proportionally represent all tiers of the judiciary, and it's not always the case. This is not the case, for example, in Ireland. In Ireland, in the commission, the board I mentioned, the Judicial Appointment Advisory Board, only court presidents are representatives of the judiciary, so it's not purely representatives, of course. And I could also give the example of France. So, and I would like to end by pointing the fact that maybe we focus too much on the role of judicial councils. Maybe because we see them as the only counterbalance to political power, but there are various internal self-governance bodies that have an impact on selection, promotion, and evaluation of judges. And this is particularly the case of court presidents. Court presidents are self-governing body, and in many countries they play a major role in judges' evaluation. And it is for me the opportunity to remind you that in our judiciaries, the management model is very presidential. It gives many power to this president. And in many countries, for example, in Czechia, minister hold the power to appoint the judges, but in practice, these are the court presidents who select them because they receive the file, they screen all the documents, etc. And this is also the case in France, where judges' careers depend on the evaluation of the president of the court, and even for their bonuses. So, of course, I don't want to emphasize too much on the power of the court president. And they are, I want also to say that they have such an important job. It's so important. They have so much to do. But it raises the question of what is the good involvement of the court president in this selection, promotion, and evaluation, and what are the counterbalance. And it raises the question of course, a judge who is not happy with his evaluation can challenge this evaluation, but that was mentioned this morning. It raises the question of what is an effective judicial review when you are a member of the judiciary. And your case is addressed by the judiciary. So it's also, I think, an important question. So I think that we cannot deny the value of involving the judiciary in the selection, promotion, and evaluation of the judges, but in the same time, the legal framework from the internal independence perspective and internal perspective should be improved.
Thank you very much, Madam Fouki. It was a wonderful comparative, I must say, analysis, giving examples of how differently structured those judiciary councils, however they are called, can be, and also you gave some very interesting examples about problematic aspects of that, or at least aspects about which one should discuss, what could be improved. There's probably no best practice in a general way, but also I found very interesting the role of the presidents of the courts, and even some maybe shadow presidents, maybe vice presidents or former vice presidents, whoever has to play a role, what role plays also the political dimension. So that is, it just shows that the fact alone that we have a judicial council does not necessarily guarantee a good outcome. So there may be quite reasonable approaches, but there are also problems. Of course, nothing is perfect, but one can improve, and one should discuss about that later, maybe. So now we can continue. Thank you so much. And first, now we have the third presentation. It's a little bit, I would say, broader, at least from the wording of the topic which was given. It's Professor Kravtsov. Professor Kravtsov, Serhii, is a professor from Luxembourg University, and I've read rightly in the web on the internet. He was formerly a postdoctoral researcher at the Max Planck Institute.
Senior fellow researcher.
Yeah, so, yeah. But basically, he's a professor, associate professor from Yaroslav Mudry University in Kharkiv, so one of the renowned centers of law in Ukraine. So he has this perspective, inner perspective Ukraine, outside view together. And what I read is also that you have an interest in arbitration and mediation, which brings in a new dimension maybe of the issue of judicial independence, whatever judicial means in this context, because of course courts always support also alternative dispute resolution, what kind of is there. But please, you have the floor, whether you want to focus it on the appointment and so on, or more broader, it's your choice.
Okay, thank you, Professor Alexander Trunk. I want to, first of all, thank Nicholas, University of Nicosia, and Professor Shimon Shedrit for a great opportunity to be here and share, I think, my experience, Ukrainian experience. My topic is independence in the context of European Union and assessing Ukrainians' implementation of the ELI Scopus European Standards of Judicial Independence. I divided my presentation for two parts. First of all, I tried to explain how it's working in Ukraine. And the second part, I want to share interesting information about the last version of Venice joint opinion in October 2025. It's a result of our common works in the direction to the European Union. Ukraine's aspiration to become a full member of the European Union is a strategic priority, explicitly direction for Ukraine. On 23 June 2022, the European Council granted Ukraine candidate status, sending a clear political signal to the country's European perspective is recognized. The opening for accession negotiation as the first Ukraine-European Union intergovernmental conference in June 2024 marked the beginning of a new historical phase. On October 2024, European Commission published second report on Ukrainian progress as a part of the European Union enlargement package. In this document, the Commission stresses that the reconstituted bodies of judicial governments must coordinate their work with other institutional reforms in order to effectively enhance the independence, impartiality, and accountability of the judiciary. Particular attention is drawn to the urgent need to rebuild public trust in the judicial system, which remain at a critically low level. Now in Ukraine, this level of trust is only 15% of all in all territory of Ukraine, especially to the Supreme Court. For now, it's if you know, I can share. Big corruption scandal was in Ukraine with the president of Supreme Court, who take 3 million euros for this for adoption a right decision from one of the big entities in Ukraine. In this context, the High Council of Justice of Ukraine is a main body who elected the judges, who is this judicially governments. Assessment a coordinating role in preparing for negotiation within the justice and legal educational bloc, in particular by organizing a screening of the relevant legislation. A further step was taken with the adoption by the Cabinet Minister of Ukraine order which approved the rules of law roadmap with negotiation cluster 1, fundamentals of the European Union accession process. This roadmap sets up a package of reform under Chapter 23, Judicial and Fundamental Rights, under Chapter 24, Justice, Freedom and Security, assigning to the High Council of Justice responsibility for implementation a range measure aimed at the modernization in judicial in line of European standard. I'm sorry. Have some slide. High Council Justice of Ukraine 2024 annual reports identify several core elements for safeguarding judicial independence. These included, first, the selection of judges on the basis of uniform criteria of integrity and professional ethics. Second, the exercise by the High Qualification Commission of Judges of Ukraine and the High Council of Justice of Ukraine of their power in judicial staffing matters. Next, an effective system of disciplinary responsibility, robust guarantees of judges' inviolability. Taken together, this element constitutes the systemic architecture of judicial independence in Ukraine. I try to describe one of these points, each of these points, I think. First, it's a selection of judges based on uniform standards for assessing integrity and professional ethics. And equally important indicator of real independence of judiciary beyond the proceeding for judicial appointment is the operation in the effective disciplinary system that maintain a proper balance between judicial accountability and protection against undue influence. Regulatory framework government's judicial selection in 2024-2025 demonstrates a clear legislative intention to establish a uniform and integrity-based proceeding. A major step in this direction was adoption by the High Council of Justice of Ukraine in December 2024 of the uniform indicator for assessing the integrity and professional ethics of judges and candidates of judicial office. This instrument plays a systematic role in ensuring a coordinated and harmonized assessment methodology across the High Council of Justice of Ukraine, the High Qualification Commission of Justice of Ukraine, and Public Integrity Council. Next, I want to describe this our difficult and maybe strange proceeding of electing appointment of the judges. Contemporary model of judicial selection remain complex and some difficulty. Legislation provided several distinct entry routes into judicial profession. Candidates may hold an academic degree in law and relevant scholarly experience, possess substantial experience as a practicing lawyer, have cumulated legal experience 5, 7, and 10 years. It depends on the instance that you want to be the judges. First instance 5 years, Court of Appeal 7 years, Supreme Court 10 years. And it's really big problem why I speak with my colleague from Poland, and in Ukraine it doesn't matter what is your experience. I mean that you cannot be professor, cannot be academic. If you work at university, if you're experienced, and if you work 5 years, if you have 30 years old, you can be judges. And without any experience practical, and it's a big problem because for now in our Supreme Courts, we fight with academical advocacy and real judges who work all their life in this proceeding. Okay. Legislation provides several distinct entry routes. I said about it. Okay. Documentary requirements imposed on candidates are extensive. Mandatory submission include the declaration of family ties, declaration of integrity, documentary proof of professional experience, employee records, contracts, income statement, and other. Evidence of legal practice, confirmation of academic degrees and scholarly activity, results of physical and narcological examination, writing a consent of special vetting and anti-corruption declaration, and proof of proficiency in the state language. But furthermore, special verification required in the High Qualification Commission of Judges to request information from a broad range of public authorities, including national policy, state judicial administration, national security and stock market commission, Ministry of Justice, National Agency for Corruption Prevention, Health Authority, Ministry of Education, Science and Security Service of Ukraine, Foreign Intelligence Service, Ministry of Defense, and other. They wait answering for all these requested for these all candidates who wants to be the judges. All this selection process in tests consists of 3 core stages: submission of documents, their review and special verification, and the qualification assessment. The qualification assessment included an examination and review of the judges of candidates' dossier, followed by interview. The exam follows a step-by-step filter logic. First of all, initial testing of cognitive abilities. Second, testing of knowledge of Ukrainian statehood. Next, examination of general and specialized legal knowledge. And finally, practical task requiring the drafting of a model judicial decision, demonstrating the ability to apply substantive and procedural law. To be honest, this final stage is more, it's a previous stage check automatically with a computer. The next is the final step, review, it's only check member of High Qualification Commission. And for now, in the Supreme Court, hearing more than 100 cases, candidate for the judges who wants to be the judges, because they think that the people who check their dossier, this practical task, it's unfair. In this proceeding. Next, it's disciplinary responsibility of judges. In line with the previous analysis concerning judicial selection procedures and the introduction of uniform integrity and ethics standards, the next crucial component for assessing the actual independence of the judiciary is the system of judicially disciplinary responsibility. Statistical data for 2024 reflected a notably high intensity of disciplinary proceeding. The High Council of Justice of Ukraine received 8,269 disciplinary complaints, and the disciplinary chamber members of the council and disciplinary inspector completed the review of 9,074 complaints, including those submitted in previous year. It's a big part of these complaints for whole territory of Ukraine. Why this problem in Ukraine? According to Article 107, the law of Ukraine of the judicial system and status, judges say that any person may submit a disciplinary complaint. In two words. It's but what is the meaning of these two words? This any and practical. Show us that more than 10,000 complaints hearing in the High Council of Justice of Ukraine for people who wasn't the party of proceeding. It's a special works. I said it's my opinion that in Ukraine there are some NGO who works to find this some problem with the judges, with declaration, with some another and 2 minutes. Okay. That's why these two words. It's any person. It's a big challenge for Ukraine for now. Why I said that? Because I try to be briefly. I said in my starting of my presentation that in this year, in October 2025, Venice Commission adopted a joint opinion about our judicial system, our reform, and they, in their reports, Venice Commission and the Directorate General of Human Rights and Rule of Law highlight that the architecture of disciplinary liability for judges in Ukraine serves as one of the most relevant indicators of whether judicial independence is generally safeguarding in practice and accordingly with the Scopus standard. The Commission welcomes Ukraine's intention to simplify the excessively detailed catalog of disciplinary offenses, as in they can improve predictably and coherence in enforcement. At the same time, it stresses that the grounds for disciplinary liability must be clear, narrowly and exhaustively defined, and the requirement of intent or gross negligence must apply to all disciplinary composition without exception. I want to, in my general conclusion, I wrote 5 points. I tried to be very quickly. This opinion, it's a result of all work our system for last 5 years. I think it's my opinion. General conclusion. First, Ukrainian system of judicial governance is undergoing of profound transformation aimed of aligning in the selection, evaluation, and disciplinary proceeding with Eastern European standard. Second, analysis confirms that disciplinary mechanism remains the most sensitive test of actual non-declarative judicial independence. On the other hand, Ukraine maintains a high level of public access to disciplinary proceeding, consistent with the European trends of strengthening judicial accountability. Every day, High Council of Justice of Ukraine translated their hearing of this disciplinary in the online, and every people can see this proceeding. It's every time. It's from Monday till Friday. Third, the research identifies ongoing risk of conflict of interest and the appearance of bias within judicial government's bodies, particularly where individuals previously engaged in public disciplinary activism later assume decision-making position in the High Council of Justice of Ukraine. Fourth, the system of judicial immunity and safeguards against interference reflect progress but still contain elements which require refinement. Thank you for your attention.
Thank you very much, Mr. Kravtsov. This was only a highly interesting illustrative insight, and Ukraine is sort of in a dilemma. On the one side, there's the war with all the consequences with are linked with that, all the, let's say, emotions and, let's say, practical handlings coming out of that. And at the same time, Ukraine needs to have reforms in different areas with a view to EU accession. Although EU accession is not a purpose maybe only for itself, but it's mostly a purpose. The reforms are something for Ukraine, and EU accession is an element of that. We will have to time to discuss it maybe a little bit later, but it's a task of an amount of a size which one cannot probably see in any other country of the world at the moment. But before we, let's say, come to the discussion, I have the honor and pleasure to welcome also Professor Giuseppe Franco Ferrari, who is a Professor Emeritus at the Bocconi University, renowned university in Milano, and he is a professor of constitutional law, public law, also with a focus, has published also in English texts on the Italian public law. So he's a very well-known scholar. Also, he was for several years vice president of the International Academy of Comparative Law. So the comparative dimension is here in his perspective, and he will talk to us about a new bill on the relationship between the prosecutors and prosecutorship and judges. So it's a matter which comes up, I would say, sometimes, because who has more importance? Is it from the socialist tradition the prosecutor who supervises the judges, or is it the judge who supervises the prosecutor, so to speak, or at least is independent? It's a kind of also mutual relationship, in which way it is balanced, and we will be very interested to hear what Professor Ferrari will tell us about that. You have the floor.
Thank you very much, Frederick. It's a pleasure to have been invited to this important seminar. I do apologize for having been compelled to cancel my participation in person, but it was due to serious familiar reasons. So I greet, first of all of you and the friends that I saw, besides yourself, Shimon, and I also noticed Amnon and all the other persons with whom we have been working over the years. Actually, the bill is no longer a bill, it's a statute, because it has been approved, meanwhile, twice, according to the Italian Constitution. There is a revision procedure which requires double joint deliberation by the chambers at a distance of about at minimum 3 months from the first one to the second one, and then it has been sanctioned by the President of the Republic. The only step which remains, but it's far from being important, is that when a statute is approved, a statute revising the Constitution is approved with a majority which needs to be higher than the absolute majority. But if it is lower than 2/3, such as in this case, then a referendum may take place when it is requested by either 500,000 electors or 1/5 of parliament. And in this case, it has been requested. So it will take place in March, and to say so, the electoral campaign has already started. All the newspapers are talking about this topic. There is a real clash among the parties and even between the scholars, because constitutional law scholars have adopted two different approaches. They are partially divided, so that this is going to be the topic in the Italian political life in the next at least 4 or 5 months. It has really become a kind of battlefield, not simply a kind of occasional political topic, but really the topic, the very topic. Well, actually, this bill belonged to the platform of the right-wing parties, the three right-wing parties which won the elections in October 2022. And this legislature, unless Parliament is dissolved at an earlier date for some reason, will last up until October 27. The referendum will take place in April, between March and April 2026. Well, I don't have time to remind you of the provisions of the Constitution concerning the judicial power, but it is enough to remind that according to the current version before the revision, prosecutors and judges, the two kinds of magistrates, enjoy perfectly the same legal and economic status. They are guaranteed against, for instance, removals, dismissals, suspensions, assignment to other offices, exactly on the same footing, unless a decision of the Superior Council of the Judiciary takes place following procedures provided by statute. Also, they have a common higher or Superior Council of the Judiciary, where they are elected. They were used to be elected together. They belong to the same body, which is composed for 2/3 by magistrates and for 1/3 by so-called lay members, which are elected by a joint session of the two chambers with a majority of 3/5 and over 2/3. In 2022, which was the last, the few months remained in the former legislature when the government was presided by Mr. Draghi, and it was not a political government but a technical one, with all the parties left, right, and the center supporting Mr. Draghi. The system was already changed, reaching a kind of limited separation between the two careers, and a new rule was introduced according to which one cannot switch an indefinite number of cases from one career to the other, but he or she can change only once in life, and if he or she comes from the prosecutorial career, in that case, he or she can move only to a seat of civil judgment, not of criminal judge. Some limitations to switching from one to the other career have already been introduced in the spring of 2022. They also changed, the Draghi majority, the way of selecting the members, both the lay and above all the gowned members of the Superior Council, because they wanted to prevent the phenomenon that was typical and that about which I already spoke in the seminars of our group on former occasions. The phenomenon of having the gowned components of the Superior Council creating groups, political groups, named, branded sometimes streams, which used to govern the promotions and the allotment of the seats, such as president of a court of appeal, of a tribunal, or prosecutor general, and so on. Apparently, the change in the electoral system introduced in 2022 has not worked at all, because again, of the 20 members of the ground component, 7 were elected in the right-wing faction, 7 in the left-wing faction, 4 in the central moderate stream, and then other 2 were declaredly independent, but both of them, after being elected, adhered to one of the groups, so that apparently nothing has changed, and life goes on in the same way, so that the new government, the new majority, decided to push hardly for the approval of the new bill, which has 2 main important points that we need to focus on. First, there would be a full separation, which implies different procedures of selection, impossibility of switching from one to the other one, and obviously the treatment will keep on being the same, but there will be 2 different superior councils, one for the prosecution and the other one for judging magistrates, which implies that the career will be governed by 2 different bodies. There will be no transversal interference between one component and the other one. And the second main point is actually there's another detail that I will emphasize just in a moment. But the second important profile is that there will be one disciplinary council, a third body, where the sanctions for, say, we unfortunately suffer from lenient interpretation of the accountability of magistrates for chronicle delays. We are famous for the length of civil procedures and even, unfortunately, of criminal procedures, which has been lamented both by the European Union and by the Strasbourg Court, and for some serious errors in criminal cases that don't use to be seriously sanctioned. Therefore, one only discipline common to the 2 components of the judiciary will decide about these sanctions, and the members of the ground members, because the lay members will keep on being elected by parliament in the same traditional way. Nothing will change. The requisite will be the same, such as professors of law or lawyers with at least 15 years of experience. But for the component of prosecutors and judges, they won't be elected anymore. There will be a kind of lottery. They will be sorted, so that this is one of the points that magistrates oppose more hardly. They will prefer to keep on electing, although the new procedure prescribes that the new sorted members will have requisites such as 20 years of experience at any level, say first, second appeal, or even cassation. What happens now? That obviously the government insists on the favorable answer by the by the people in the next referendum. And obviously there is a partial position by a segment of my colleagues of public lawyers and constitutional law professors. Some of them, on the other side, do support the project, so that we are writing and discussing in all the possible places, such as TV, radio, newspapers, scientific reviews, and so on. Just to give a really short exposition of what is the political climate in this moment, two phrases concerning one, the position of the government, and the other one, the position of the opposers. According to the government, it should be common sense that in Western democracy, judges are not only responsible for the protection of individual rights, but also must play a pivotal role in the administration of the economy, of the environment, and technology. However, the Italian anomaly consists of an insatiable judiciary that, through the assimilation of prosecutors and judges, fails to perceive the limits of the power vested in it, combined with the problems generated by the application, the complete implementation of criminal procedure. Unlimited spaces have been occupied, created, fed, or eliminated arbitrarily.
I'm sorry to interrupt. Please.
Seeking consensus.
1 minute, please.
Pardon, 1 minute?
Yes.
Okay, I will try. Seeking consensus without representation, governing while being bureaucrats. On the other side, the opposition, aroused by such interpretation, is supported, for instance, by the National Association of Italian Magistrates, although a segment of them favor the reform, repeatedly expressed concern, initiated some demonstration in which they showed the text of the Constitution or exhibited, and even warned about a possible strike which should take place before the referendum. In mid-October, the Italian Association has persuaded the International Association of Judges, IAJ, to during a meeting in Baku, Azerbaijan, to deliver the Italian government an address during the yearly meeting, labeling as strange and unprecedented the revision of the Constitution, and suggesting that it could alter the balance of powers and damage the reputation that the Italian judiciary has been able to achieve over time. So that public law scholars are as well divided, as expected. I don't have time at this point to expose in detail the positions of many scholars. As far as I know, nobody of us has written anything in English supporting or criticizing the bill, so that I am unable to provide materials, because all of us have written up until now in Italian only. However, I have written a text so that I guess all of you who are interested in such a problem will have a full chance of reading my short version of the problem. Thank you for the patience, and again, apologies for not being there with you in person.
Thank you. Thank you very much. You had also the difficult task to be the last speaker in this panel. It was very interesting also to hear about this really topical development of, let's say, in Italy with regard to the relationship of prosecutors and judges. Thank you so much. We are now at a point where I promised to finish. Now I ask the organizer, do we have questions? How many?
5 minutes.
We have 5 minutes for questions. 5 Minuten für Fragen, 5 minutes. 5 minuti per questioni.
It's especially for a French colleague, but anyone can answer. Has there ever been any country that has tried to submit disputes where the judiciary was personally involved, a party, to arbitration? Just like we do with commercial disputes, and each party can appoint an arbitrator? Would that be a solution?
No, but the arbitrators we have are the European courts. Because, for example, in France, we have some judges who challenge some administrative measures taken by the Minister of Justice. So also we have in France, we have two separate jurisdictions, the ordinary courts and the administrative courts. And the French administrative courts are managed by the Supreme Administrative Court. So there are some cases of administrative measures against administrative jurors that was challenged by the European courts. But no, there is no case of arbitration because.
Would you think it is arbitrable? Would be a public matter dispute, probably.
That depends on your law and arbitration, no?
No, well, it depends on public law.
Many countries in Western Europe or in Europe many countries have liberalized arbitration in public affairs in recent decades, also under influence of international organizations who promote this. And so we have lifted the ban that arbitration is impossible in public affairs or public order affairs. No, there are some limits still.
Well,
but
I don't know any cases, but I agree with you. This is a kind of manner of managing this question of external review. And effective review, because we have, it's true that we have the problem. So we have the European courts, and it makes it think that we do not have mediation, internal mediation. I do not know that. So I think we should be imaginative. I agree with you.
Very short. You were talking about this problems with judiciary councils, which is very interesting, and of course it is the question whether the future, we have very different judiciary councils. We are talking about judiciary councils, but of course we are completely different institutions, so sometimes it is only a shell, and when it must be really explained what this meant. But I wanted only to refer to our Monscopus standards, that we are trying intentionally to describe more the procedure, and not really, we do not suggest that the Judiciary Council is the mandatory requirement for proper appointment of judges. We were trying to show how the balanced appointment should look like, but we are absolutely omitting telling this that there is a necessity for such kind of body in assistance.
Yeah, there can also be very differentiated approaches. It can be, for example, that the appointment of a judge is in the hand of a ministry, but the disciplinary issue could be in another hand.
May I ask a question to Professor Ferrari? I would like his opinion. My understanding of this reform is that it could weaken the judiciary, because when you separate the prosecutors and the judges, maybe the goal is to weaken the judiciary, because we know that Italy is the example of a strong judiciary. So do you think that this is the issue?
Well, this is the real central question. Personally, I don't believe that separating the two councils or sorting will diminish the strength of the judicial power as such. Speaking to friends who work both as prosecutors and judges, my impression is that prosecutors nowadays in the common judicial body, in the common superior council, prosecutors enjoy more importance than their numerical weight would allow them, because, you know, we have about 1,800 prosecutors and 8,000 judges, but both in in the real weight inside the body, and in the, I dare say, political weight that they have, and that they enjoy just starting important prosecutions. They probably are able to condition the judging component more than real weight should allow them to display. But wait, I mean, the prosecution, well, but separation is more or less, should be more or less like in France, between the parquet and the siège. The only problem is, can one of them switch indefinitely from one career to the other? May a prosecutor who has been working as such for 20 years just cancel from his brain the prosecutorial attitude and start to be totally fair and capable of giving the two parties the same footing or not? You know, we are, you are experiencing France, I guess, more or less with President Sarkozy and the other investigations against politicians, more or less the same experience that in Italy started at the beginning of the 90s with the famous Clean Hands, Mani Pulite investigation. But after that, maybe in these days, for instance, there's an important action against all the fashion firms, some of them Italians and some of other French, working in Italy, such as Armani, Prada, Saint Laurent, and so on, because they are accused of contracting out most of the most part of the production without checking whether the firms which work in the contracting out way are correct in the use of the manpower. Obviously, according to general principles, you know, the main producer has carries no responsibility for the civil or labor conduct of other subjects to which the work has been contracting out. But this story is going in the newspapers of the whole world, giving the impression that the Italian fashion sector, which is not exactly the last part of our economy, is totally, you know, rotten due to such an experience. So apparently, the prosecutors are not going to lose authority or to be put in conditions of carrying out less investigations. This is my personal opinion.